my name is Jason Asmus, here from Monterey. I attended a for-profit university that had an arbitration clause within the contract. And I don't expect you guys to read the whole packet that I'm giving you right now, but what that shows, and very interestingly, and it touches a little bit on the subjects that we've been dealing with today, is there was a designation of arbitration within that case, and it was actually the commercial rules for the American Arbitration Association, which will go into further the claim suppression because those commercial rules cost $1,275 for me to file a dispute. Within that context, the Kaplan University, or the university that I was at, withheld my transcripts. It ended up there was a clerical error, there was a mistake, but nonetheless, it took me several years before I could actually get my student transcripts to transfer out to another school because I was under the presumption that I would have to pay that amount of money, whereas a small claim would have been $50. Even if I filed an actual Superior Court civil case, that would have been, I think, about $450 at the most. So that was really part of my concern, and it deals with the issue of it is dissuasion. It did prevent me from filing any claims and from taking my case anywhere. Another issue is once I got into the arbitration, we went through discovery. And I've done some work for civil attorneys. I've done criminal law, I've done family law, I've done civil litigation. So I'm usually the guy that ended up working on some of the discovery issues. And I will say the one big concern that I had is when we did discovery, I received a lot of objections from the opposition. They claim privilege, but they never state the privilege that they were claiming. They never actually filed a privilege log. So it was just kind of more like privilege. And that was the end of the story, and it never went any further. Those things that I was requesting were documents that really should have been discussed thoroughly. It was something that I needed to actually prove my claims because I had 4 claims within the case. And it basically ended up, I think, depriving me of justice in that particular instance. And I know for a fact, because I've done some work with attorneys, if that would have been in a court context, I believe the outcome would have been entirely different.
Thank you very much. Appreciate your persistence here, and appreciate your comments. These are the kinds of real situations that we need to hear more about, and we get a lot of conflicting points of view, but it is the real human stories that I think make the difference. So thank you so much for.
And just to clarify too, my case the lifeline of the case was about 9 months. So I mean, it did take a pretty good long time before we actually got anywhere.
Great, thank you.
Thank you very much.
Anyone else? Yes, sir.
Thank you. I'm taking this opportunity as a member of the public, but I would like to also disclose that I've been an arbitrator with the AAA for 24 years and am active on their panel. I take consumer cases, intellectual property cases, construction cases, a variety of things.
Could you tell us your name, sir?
Bob Flack, F-L-A-C-K, and I've met several of your staff and have enjoyed those conversations. I'd like to talk about a couple of things. The repeat user issue is something that's been brought up several times here. I think you'll find that more a function of the agency as opposed to the individual. For example, I've been, again, with the AAA for 24 years, and I've never had the same parties. Same attorney sometimes, but never had the same parties in the 24 years. Never happened. The way they handle class action cases, where you would normally go through a class action, they stack up several cases. They're all very similar, but in order to avoid this arbitrator to arbitrator bias that may unfold over time, seeing the same information, what they do is they spread that out. So if you've got 10 cases that may have qualified as a class action when that was permissible, they will spread that out among several arbitrators, so there isn't the bias that's developed. There is no repeat effect. The institution, and AAA, let's reinforce, is a nonprofit, and I'm glad that they received the professional recognition they have received here. I think they deserve it. But they take steps as an institution to avoid those kinds of problems. In the case of AAA, I can speak from personal experience. You asked the question, is arbitration fair? And I will answer that question. I've got no organizational constraints on me at all. I think in many cases it's more fair than the current court system. With the underfunding of the courts, the pressure to close files, it's a real constraint there, and particularly when you're talking about small claims. If you increase the amount there, you're just going to get more cases shoved in the system that's inadequate to proceed, and those systems are, you may get 20 minutes with a judge in small claims, and you get much more attention in arbitration.
Let me just jump in and ask you a question. This gentleman who just spoke talked about the fact that there were no rights of discovery, which is part of the issue, and that indeed, it's sometimes when you're asked to try to kind of define the whole in a bagel, it's very hard to do that without a picture of the bagel. And
I actually sat down with the gentleman and talked with him about his particular issue.
well, his is an example. I'm not, what do you do in situations? I mean, there's a reason we have rules of discovery. There's a reason that we have the rules of civil procedure in order to try to make the system fair. How do you deal with that? Granted that there are benefits to having a speedy proceeding and to have something move expeditiously and as cost effectively, but if the cost is justice, how do you explain that?
The fundamental theme these days, both in the court system and in arbitration, is the reasonableness of discovery. You'll find that judges are constraining discovery to be reasonable given the nature of the matter, and the same thing occurs in arbitration. Just this morning, I scheduled a second hearing on the matter of discovery for a consumer case where it's probably, and they don't tell me this because that's not part of the information that's provided to an individual arbitrator, it's probably a class action equivalent where they're stacking up a bunch of cases, and somebody's coming to me asking for more discovery, and I'm asking them to prove up their need for that. And so I'll have one side discuss that need for those that information, the other side defend their need for withholding that. That process is very similar to what happens in court, except it's more efficient. We handle it by telephone generally and by fax, email, pardon me. But it's a very similar process, and where the gentleman was disadvantaged was not so much in discovery as much as the fact that he had there were poor disclosures and no enforcement of the disclosure process. With the AAA, not only do you need to disclose before you're assigned a case, but you have a continuing duty to disclose anything that may give the appearance of an impropriety. In one particular case about 10 years ago, I disclosed that my wife sold a piece of pottery to one of the plaintiff's father. That's how far removed this thing is. And I was accepted for the case, but go ahead, I don't interrupt.
No, I wanted to, it's after 5 o'clock and we do need to shut down, so if you could go very quickly.
Two more points. There are a lot of things. Let's say that Concepcion is a case we all wish had not been resolved in that way. We've got a number of problems with again, the repeat user syndrome. I have never within the AAA, been advised, cautioned, counseled to rule one way or the other. It's been completely up to me and my judicial ethics. These are reviewed for consistency, but the determination is completely up to me. I've never been pressured to rule in favor of a company, and we're in favor of a consumer. And I can say that within the AAA. And there are examples with other institutions where you have more direct control over that within the state government, where that is not the case. And I've given your staff examples of situations where state agencies have institutional control over this process and are guiding people down paths that disadvantage consumers. And I recommend you take a look at that, and I can provide more information if you'd like.
Great.
The last item I want to say is that California is different. California is different. We should resist things like Concepcion. It was wrongly decided, and there are a lot of pressures to have a uniform legal system here. Following up, I don't know if you remember the Powell memo of the mid-'60s, but it's not by accident that these things happen, and I think we should resist that, the Concepcion case, and all other matters, including the Uniform Mediation Act, which may come before you. Again, it doesn't relate to California's needs. California is different. California, in my view, is better. Thank you.
Thank you very much. I want to thank everyone for participating, members of the panel, staff for putting together, I think, a very helpful an interesting hearing. There's probably as many questions raised as answered, but I think it is helping us with some clarity as we move forward to try to fashion the best public policy that is in the interest of the people of California while dealing with the struggles and the challenges of a Supreme Court that has ruled in such a fashion and preempted the field arguably in such ways that we are going to be challenged to work around that, and hopefully we'll be able to come up with some resolutions that truly will be in the best interest of the people of our state. So unless there's anything further, we are adjourned. Thank you.
Thank you.